Hi everybody and welcome to Lawyers Rob. Today I'm going to talk about a topic that's very specific, but if you've gone through one of these or you're going through one right now, I think you're going to appreciate the information I give you. I'm talking about TTAB proceedings. Now these are things that occur during the trademark process when you're trying to get your trademark or your brand approved by the USPTO and someone opposes your application. So what do? Well, we'll go over that and I'll give you a few tips on how to handle it. Let's rock. So let's start by talking about what a TTAB proceeding actually is. There are actually two main proceedings. One is a notice of opposition, and that occurs when someone is filing a notice before your application is approved, and they're saying that your application should not be approved because there's a conflict with their mark. A second way is a cancellation proceeding. Now that occurs after your mark is registered and you've gone on and started building your brand, and someone comes along and says, wait, you shouldn't have been approved, and we're going to try to cancel your mark. You may also be alerted if someone's going to oppose your mark if you receive a notice of extension of time to oppose. So the first thing you really need to do is have the pleading reviewed, whether it's a notice of opposition or petition to cancel. So you're going to want to look to see how valid this claim actually is. Are the marks very similar? Were they using their mark before yours? Are the classes the same? Are the descriptions the same? There are all types of things that you have to look at to see if the claim is valid. Sometimes companies just file these TTAB proceedings just to frustrate you or to see if it'll go away. If they have a history of it, you can look that up and see if this is the type of thing that they do, and it kind of gives you an idea of what you're dealing with. Next, you've got to understand that the opposer or the petitioner really has nothing to lose until you answer the claim, because if you don't answer, they've automatically won. Now you can file an answer on your own. Maybe you get advice from an attorney who helps you draft it and then you file it under your own name. Or you could hire an attorney who files it on your behalf, and then he's the attorney of record and goes through the process for you. Now I strongly advise you to get counsel either representing you or someone who at least advises you as you go through the process. Be aware that these are nothing but federal cases on paper. So you have discovery, and you have a lot of disclosure requirements. There's a lot that goes into it, and you have a lot of technicality that goes into the proceedings. Whether or not to fight is an issue in itself. I've seen the gamut. I've seen people who have ignored the notices of opposition, and then they end up losing their application. And also I've seen people who have fought in opposition, and it's gone on for 6 or 7 years. In my opinion, some kind of settlement is probably the best solution for both parties. Now, you obviously filed a trademark application to protect your brand. So don't let a TTAB proceeding just automatically derail all your efforts. Sometimes it's worth fighting for. Sometimes not, but you need to do the analysis and do what's best for your business. I hope you found this video helpful. If you have any questions, either leave me a comment or contact me. My information should be below.